Over the past several years, there has just been a gigantic wave of sexual harassment claims in the media, congressmen, culminating, of course, in the Judge Brett Kavanaugh hearings, which kind of focused on a sexual assault issue. And now that the dust has kind of settled on those kinds of issues, and again, just putting the politics aside of these, it's important that listeners and employees understand how these sexual harassment claims are litigated, what the key issues are, and no matter what you're hearing in the media about harassment, about sexual assault, the media does not control the legal elements that have to be met in these cases. Now, one thing about the Kavanaugh hearing, which you heard over and over, was every senator pretty much agreed that, they even used the phrase, this is not a court of law. Okay, now what does that mean? That means that because the Senate is not a court of law, and the Senate is a place for politics and political opinion, whether this Dr. Ford actually proved that Judge Kavanaugh had assaulted her or not doesn't really matter. If enough people in the country think that she did, or thought that whether she did or didn't, we just don't want someone on the Supreme Court with those kinds of allegations, the Senate had the power to deny that Supreme Court nomination. That is not a court of law. A court of law requires proof. It requires that the elements of sexual harassment or a sexual assault were met legally. It requires that statutes of limitations were followed. So someone coming out 35 years later against her or his employer saying, wow, 35 years ago I was working at a company, I was sexually harassed, that loses. You missed the 300 days to complain to the EEOC. That's really, really important. The second trend that we're finding in the media is what I like to call sudden outrage. That one day a group of people determined, okay, that, for example, the Washington Redskins name is somehow offensive to Native Americans, or this week or last week, the phrase, baby, it's cold outside, is somehow now very offensive. And the question really is, what do I do if I hear those words and I find them offensive? Can I rely on, hey, my manager should be watching the news, should be following the friends on Facebook, should be into social media to pick up what is trendy now in terms of being offensive? And the answer to that is no. The manager does not have to search the internet, does not have to follow trends to find out what's offensive to some. Unless this is a well-established offensive term that, and the courts actually do a good job of highlighting things like someone used the N-word. Judge T.S. Ellis, the judge in the Paul Manafort trial in Virginia, just wrote a wonderful opinion on anti-Semitism and the phrase Jewish money. Some of these things are just inherent, as Judge Ellis says. People should know. People should know that, for example, for hundreds of years, well over 1,000 years, Jewish people had this issue associated that these are the financiers, these are the people that control the banks, and when an employee goes to his new job and is told, yeah, you're connected to Jewish money, so Judge Ellis made it a point in his opinion that said that immediately makes someone unwelcome, and that is a well-established stereotype for hundreds of years, okay? That the employer should know about. The phrase, baby, it's cold outside, that to expect that within 3 weeks that the employer, in fact, I guess would the new standard be that does the employer have to create a job now? I mean, for someone, think about this, for someone right out of college, we're going to have you, and what your job is going to be is you're going to be an internet surfer, media person to discover every other week a new phrase which is offensive, determined by whomever, which is part of the problem. It's not well established. It's been out for a couple weeks, and you, the new graduate from college, is going to update our employee handbook every, week or two to find out the next offensive term. That is not how the law works. So if an employee hears a phrase that the employee believes is anti-Semitic, religious, anti-gay, you name the minority group, all right? And if it's not so established, like the N-word, like the Jewish money phrase are two that jump out, you, the employee, have to give notice to the supervisor and to the HR department that you find that phrase offensive. And you find it racially offensive. You find it religiously offensive. You find it's offensive to your sexual orientation. Whatever the Title VII or other protected basis is, you can't rely on everybody on the phrase, everybody should know this. And how does this affect me, just some employee? And it can be women who are sexually harassed, and we know it can be men who are sexually harassed. We know it can be men harassing men. We know it can be men harassing women, women harassing men, women harassing women. So it's just an explosion of these claims. And I think that it's a really good idea to review what the basic elements of a sexual harassment claim are that an employee has to show in order to win, and also to review what's going on in the media with claims that may not have all the elements, and how are they getting through, and whether any of this could apply to employees. So first, in order to successfully advance a sexual harassment claim, an employee has to show that, number one, he or she suffered harassment because of sex, because of her or his sex. Number two, that the employer should have known of the harassment and failed to take advantage or failed to take remedial action. And third, that there was a hostile environment that interfered with that person's work. Okay, element one, what is harassment? Harassment has to be something that is severe or pervasive, which alters the conditions of employment and creates an abusive working environment. And the conduct usually has to be extreme enough to amount to a change in the terms and conditions of employment. And it has to be both objectively offensive and subjectively offensive. It can't just be that a typical person would find this offensive and you didn't, or you found it offensive. That's more often the case, is where the employee found it offensive, but it really wasn't an objective standard. The second element, how does the employer know about this? Well, it's very simple. It's called you complain. The employee must complain about sexual harassment to have any chance of winning this case. Certainly, I have heard over the years, I'm scared. I'm scared of complaining. I know of other people that complained and nothing happened. The company did nothing, and in fact, these people were retaliated against. Okay, let's go through that defense of I'm scared. All right. I will tell you categorically, I'm scared loses. The only time that it wins is that you, the employee, have real hard evidence that other people complained and were retaliated against. Okay, this is not rumors. All right. So if you say I'm scared because there were rumors that other people were retaliated against when they complained, that loses. A court will find rumors is not enough. You had to have know of cases. You had to really know of people. It cannot be a standard of I think that's what happened. And generally, the solution to being scared, which is normal and natural, and you should be scared. I mean, there is a real element here that your career's at stake. You're being sexually harassed. What do you do about it? But the reaction should not be, I'm scared, let me do nothing. The reaction has to be, this is the time to retain a lawyer, an employment lawyer, who practices in this area and can write the necessary letters to the company and give the company notice of your complaint of sexual harassment. And the notice is not that simple. The notice has to say the words sexual harassment or something very close. Right? I'll tell you some cardinal sins that employees use to ruin their cases is they complain, but not about sexual harassment. And they use words like, I find my supervisor unprofessional, rude, overbearing. All of those characterizations lose in terms of a sexual harassment case. You had to put the employer on notice that this was more than just the supervisor was unprofessional or rude. Supervisor made advances, sexual advances. That's really the key. And the reason for this is that the employer has a defense, it's called an affirmative defense, that the employer must prove by preponderance of evidence that A, it exercised reasonable care to prevent and correct promptly any sexually harassing behavior, and two, the employee failed to take advantage of any preventive or corrective opportunities provided by the employer. Okay, what are these preventive and corrective opportunities? Simple. They're called sexual harassment policies. Every single company in America has them. If they don't, they won't exist for very long if they employ any number of people in any situation where there are going to be employees alone with other employees, which is virtually every single company in America. Many states even don't even have a requirement, a certain minimum number of employees that have to be employed for the company to be liable for sexual harassment. For example, New York State, a company could have 2 people. It doesn't matter. If the person's being sexually harassed, that person is covered. So you have to take advantage of the ability to complain, and you have to get that policy, and you have to find out what the best way is, or that the company wants you to complain, and you have to do that, otherwise you will lose the case. Finally, the third element is the environment truly hostile. All right, I once had a case, and I joke about this, but I represented this person. This was around 10 or so years ago. And I talked about this when I addressed the bar back in October of D.C. when I was a featured speaker on sexual harassment, one of the issues. And I had a client. She contended she was being sexually harassed by her supervisor. The case was going ho-hum. until at deposition she's asked a question by the defense lawyer, isn't it true that you were sharing an apartment after work with the alleged harasser? Well, that kind of sort of ruined the case. I mean, you can't on one hand claim that your boss at work is sexually harassing you, but after work, you guys are going out and you're living together in an apartment. I mean, that kind of does ruin your case. So keep that in mind. There are strict deadlines for filing sexual harassment cases. EEOC requires 300 days. Some states require 180. You have to check this out wherever you are. I do want to talk about some of these media cases in terms of, you keep on hearing in the news of people who are complaining about sexual harassment years and years later against famous people. Matt Lauer, John Conyers, and of course the original sexual harasser big claim, which was against Bill Cosby. And that was by Janice Dickinson, one of the people who was a model, and we'll get into her case. But the question is, how is it that someone can complain about sexual harassment many, many years after the EEOC requirements and still have a case? So there's a few answers that I think the public should know about. One is, there is a difference between destroying someone's career and winning a lawsuit. I mean, maybe there is an element here that one of these attorneys for one of the women who has a high-profile case contacted the network and made some sort of demand that said, look, if you don't pay us X amount of money, we're going to sue. And a lot of times companies will pay just to get rid of this. That does happen. Now, I will say this. I have never had a case of sexual harassment beyond the time limits. I have sued companies. I have sued media companies on discrimination and sexual harassment. So it's not something that I would do, but there is an element here of publicity, just to avoid the publicity. Some of them are doing that. And there's another element here, is that the person didn't know of the harm until later. All right? For example, you have a sexual harassment case and the woman failed to get promoted, and she never linked the ability to get promoted with her refusal to have sex with a superior. Years later, she learns of a scandal in that company, a sexual harassment scandal. She puts two and two together and says, hey, 5 years ago when I didn't get promoted, that could be the reason. So there are plaintiffs who attempt that, and sometimes that does win. Third, your sexual harassment case could be brought in some other way other than sexual harassment. Janice Dickinson, who accused Bill Cosby of rape. What happened was Cosby's lawyers issued a public statement that this is a lie, and they threatened media outlets from reporting her story. Janice Dickinson claimed that that action of Cosby through his lawyers doing that, of threatening litigation and saying that she was a liar, was defamatory. And that's essentially her case. And her case made it all the way to trial. But a defamation case is a lot different than a sexual harassment case, because now you have issues of, okay, how were you harmed? And a lot of people in defamation cases are not really harmed. They're just there's no real loss of income. In fact, I think one argument that I would make if I were Cosby's lawyers is that she was actually making money off this case. She's actually making money. That now she's in the spotlight and she's doing all these interviews on CNN and everywhere else, and that's boomed her career. So my point is, you don't want to let it get to that. You don't want to have to think about how else could you bring a sexual harassment case? The jury sympathy is going to be with you on sexual harassment if you follow the deadlines. And that's why it's essential that if you believe you're a victim of sexual harassment, you have to do something about it right now. You have to contact an attorney right now to assert your legal rights.